Hey guys, thank you. Thank you so much for coming. My name is Jed Greenberg. I'm a programming director here at the University of Chicago Federalist Society. And today it's my pleasure to introduce to you guys Prerak Shah and Jonathan Mazur, Professor Jonathan Mazur, who will be commentating on our event. Now, Mr. Shah is a current of counsel in the Houston office of Gibson, Dunn & Crutcher. Prior to that, he served as the acting United States Attorney for the Northern District of Texas. Mr. Shah graduated with his BS from Pitt and is a JD with honors from the University of Chicago Law School. After law school, he joined the Dallas office of Gibson, Dunn & Crutcher before serving with the Texas Attorney General in the Texas Solicitor's General Office. After that, he went to D.C., eventually becoming Chief Counsel and Chief of Staff for Senator Ted Cruz. He then joined the Justice Department as an Deputy Associate and Deputy Assistant Attorney General before he went to Dallas to become a United States Attorney. Now, Professor Mazur is the John P. Wilson Professor of Law at the University of Chicago. Professor Mazur graduated from Stanford University with his BS and a BA in political science, and subsequently Harvard Law School, where he graduated magna cum laude. Professor Mazur clerked for Judges Patel on the Northern District of California and Judge Posner on the 7th Circuit, and then served as a Bigelow Fellow. At the law school, Professor Mazur has served as Deputy Dean and currently serves as the Director of the Wachtell, Lipton, Rosen, Katz Program in Behavioral Law, Finance, and Economics. Please join me in welcoming our speakers.
Thank you for the welcome, Jed. Thanks for having me. I'm glad to be back at the law school, and also particularly glad to be debating Professor Mazur because he was my 1L crim law professor 15 years ago, which was his first year as a professor. And I remember thinking at the time that it was interesting and it was fun learning about criminal law, but why is this a required 1L class? I'm never going to practice criminal law ever. I was going to go do corporate work and all that. Then fast forward 15 years and that is all I do in my life. So you never know what 1L classes end up being actually more useful than it ended up being. So title of this talk, Our Nation's Under Incarceration Problem, intentionally aggressive. But also when people show up. So I've given this speech, though, across the country a number of times. And I always usually start out with a somewhat deeper dive into local crime stats, because I'm talking in Indianapolis, San Antonio, all these other, Albuquerque, all these other places. I'm actually not going to bother with that, just in the interest of time, because A, you guys are students from all around the country, so I think you're probably a little less invested in Chicago's past, present, and future. And two, because it is Chicago. I don't really need to spend a lot of time talking about whether your city has a crime problem, because it is Chicago. I think we all know how bad it's gotten here, particularly in recent years. It was bad when I was a student. I think it's gotten immeasurably worse since then. But this isn't just the Chicago problem, of course. It's a national epidemic. More than 13 big cities, of the biggest cities, including Austin, Philadelphia, Portland, set all-time records for homicide, in 2021. When you look at the news, homicide rates get a lot of attention, but I actually do think it is good to focus on homicide rates. Generally speaking, reporting on crime is difficult. There's often different reporting standards. You often have underreporting both by the government and by certain communities who don't report all crimes that might occur. It is hard to hide a body. So generally speaking, when someone has been murdered, that is a stat that is actually fairly well tracked and well understood. So for the most part, the murder rate is something you can't doctor. So talking about homicide rates is a great measure of these things. But even if you look outside of homicides and look at what is reported, it actually has been an across-the-board increase in violent crime from assaults, carjackings, armed robbery, sexual assaults. These numbers did go down a little bit in 2022 from record highs in 2021, but they're still at a high level compared to a few years ago and much higher compared to the downward trend we've been seeing over the last couple decades. But despite this increase in violent crime, which has now been happening for about 2 to 4 years, incarceration rates in this country are actually still relatively down across the board. So in 2020, for example, we had the lowest incarceration rate since 1992. And it is trending down despite this increase in violent crime. So the US prison population, again, a very hard number to necessarily get accurate because you have federal, state, local. Some people count immigration detention, some people don't, so haven't been charged with crime. But to look at one number, US prison population was about 1.2 million at the end of the year of 2021, which is a 1% decrease from 2020, but a 25% decrease from 2011. So generally speaking, incarceration rates are going down, even if over that same time period, crime was going up. So the question is, what can we do about this this increase in violent crime, and what role does incarceration play in that? I wish I had an easy answer for you, but I really don't. It's a bit of a cop-out to say that the causes of crime going up or down is due to a lot of complex factors, but it's true. It is a complex system for why crime occurs in this country, and it changes based on location, based on different types of crimes, different societal conditions. So what I want to focus on today is actually a little bit narrower. One is I want to focus on at least one of the issues that I think plays a significant role in violent crime in cities, and also what can be done at a policy level to combat that. And then I want to talk a little bit about a couple of misconceptions, I think, regarding the debate on violent crime and incarceration, ones that I think are affecting our policy debates on these issues in a negative way. And then I want to go off on a tangent because I got interested in something last week, so I'm on a tangent. I'm going to talk to you guys about it. It's still related to incarceration, though, and criminal law. All right, so the first thing. The one thing I want to start about that is practical, and I think that states can actually fix, and a number of states are trying to fix it, is state bail bond systems. So the title of this talk is America's Under-Incarceration Problem. Most people assume that means that I think more people should be convicted of more crimes and go to jail for longer sentences. That's true, I do think that. But what I actually want to talk about first is a completely different kind of incarceration, pre-trial incarceration. So a little bit of a background for folks that aren't familiar. I think most people are generally familiar with how federal systems work. It's certainly true that Chicago students, on the whole, when they graduate, they're going to be involved, to the extent they're involved in criminal law at all, in the federal system, both in terms of where you guys will clerk, and if you guys go to become prosecutors, for the most part, our graduates become AUSAs. A few become ADAs, but predominantly to go into the federal system. The federal system is actually pretty straightforward when it comes to pretrial detention. Just oversimplifying things a lot. When you are arrested, you eventually get brought before a federal magistrate judge, and that magistrate judge will determine whether you're going to be detained pending trial or if you should be released, either with some conditions or without them. Again, not to go too deep in the details, but the important thing for our purposes is that in the federal system, a judge has the authority to detain a defendant pending trial if they determine that either the defendant poses a flight risk or the defendant is a potential threat to his community or others, including whether the defendant would commit new crimes upon release. For the most part, this system works well. When I was U.S. attorney, were there situations where a judge let someone go that I thought shouldn't detain? Sure, but that's how our system works, an adversarial system for a reason. On the whole, it's a good system. State systems are very different. Most of them, not all, but most of them have cash bond systems, and these systems are terrible. Again, I'm going to oversimplify the systems for our discussion today because states do vary a great deal on this, but the essential aspects of both systems are the same. Generally speaking, when you go in front of a judge after you've been arrested, that judge will set a bail amount. The defendant either ponies up that cash themselves or gets a bail bondsman to pay the bond. In that situation, you usually pay a small fee, between 5 to 10% of the total amount, and the bondsman posts the full amount on your behalf. And a judge can also choose to let the defendant go without any bail, or if you can't pay bail, you go to jail. So in many states, the big difference between the state system and the federal system is that with a few exceptions, a state court judge has to order bail. So take Texas, for example, where I'm from. In Texas, with a few exceptions, a state court judge has to order bail. And the reason for this is actually the Texas Constitution. In the Texas Constitution, it actually says that every criminal suspect must be offered bail unless the defendant is charged with capital murder or meets certain very unique criteria for a number of repeat violent felonies, prior convictions for that. This is true for a lot of states. It's actually in their constitutions. I don't know, there used to be a comparative constitutional law class that looked like federal and state constitutions here. I don't know if it still exists, but it's actually a fascinating subject people want to look at. But most state constitutions are weirdly more protective of rights because of the history of how those states came into existence. In Texas, for example, despite its reputation as a very big red state, its constitution includes a number of uniquely Texas constitutional provisions, including, for example, it is unconstitutional in Texas to outlaw someone. It's not a thing that happens often, but it is in fact unconstitutional if anyone tries to outlaw you. Anyway, going back to the bail system. So what this means in Texas and many other states, that unless a defendant is charged with capital murder or meets certain criteria for repeat violent felonies, the judge cannot detain that defendant, has to afford that defendant bail, no matter how dangerous they think that defendant is. And this system, this cash bail system, is terrible. It's one of the dumbest systems you can have because it's both over and under inclusive. On the one hand, this is a common actually criticism you see on cash bond systems from folks that are more left of center, is that you can have individuals who are not dangerous, who are not flight risks, who are nonetheless stuck in pretrial detention because they can't pay for a bond. And they take up, not only are they being locked up when they don't need to be, but just as a purely economic matter, they're taking up prison space, they're costing the state money for reasons that need not exist. On the other hand, and even more concerning to me at least, is you can have really dangerous people out there who are getting out of jail simply because they're able to post a bond. And a bail system where you cannot detain people because they are dangerous to the community can have devastating consequences. People are dead because of this type of bond system. Now, not many people have done fulsome studies on this nationwide as opposed to just anecdotal research, which is always a little bit misleading no matter which side you're on. But there are some organizations that are trying to reform bail laws in Texas that have looked at some of this data. Again, they're not well funded, but they're trying. And I think this data is still useful because I have no reason to believe that Houston, for example, will be dramatically different from many other big cities on these issues. So if you look just Harris County, Texas, which is where Houston is, where I live, over 150 people have been murdered at the hands of people that were already out on bond at the time they committed the murder. That's over 150 people that are dead today in just one city in America that could potentially be alive if their killer had been detained when they had previously been arrested. And that's just the numbers on murder. The numbers on other violent crimes or even property crimes committed by people out on bond is astronomical. So what can be done about this? So the obvious answer is constitutional amendment in these states and legislative changes. It is something that people are working on. So Texas, they're working on that. I spoke in Indiana a couple weeks ago, and the week I was there, a state legislator announced an amendment to the Indiana Constitution, which I think has a decent chance of passing, which would give judges the discretion, not required, but the discretion to detain someone if they believe that they're a danger to the community. I'm heartened by seeing some of these changes because I think this is one of the few areas where we can, Republicans and Democrats can find ways to compromise, especially on the cash bond system. If a lot of folks want to get rid of cash bonds, they think it's over inclusive in people. That's great. I'm happy to compromise on those issues in order to give judges the discretion on the other hand to detain people with or without cash otherwise. But one local note. So as I was looking at this, Illinois actually did pass legislation just last year on pretrial detention. My understanding is, and if there are experts on this, I don't know if you followed the Illinois law change, Illinois passed a law that will phase out cash bail completely and instead require judges to impose other restrictions in order to ensure that a defendant shows up to court. And truth be told, I'm actually fine with getting rid of cash bail requirements. Illinois actually used to be pretty decent on the bond issue because they did allow judges to nonetheless detain defendants based on danger of the community. But one thing Illinois did in this latest batch of reforms, I do think is kind of insane. Getting rid of cash bail, totally fine. But what they also did was they changed the standard for when someone can be detained. Now, prosecutors need to show that a defendant poses a, quote, threat to a, quote, specific identifiable person or persons, rather than a more general threat to the community or class of persons. As a practical matter, from the perspective of a prosecutor, that is a significantly higher burden. It's one thing to say that this person has threatened the life of this specific other person, therefore they should be detained. That's great. If you have that scenario, awesome. It sometimes exists in gang scenarios when there's a gang war going on. But more generally speaking, if you're arresting someone who's committing violent crimes against the general populace, assaulting, robbery, all that sort of stuff. That does not count as an identifiable set of persons. It can't be the community at large. So for individuals like that, you will no longer be able to detain them. Even worse, this new law in Illinois creates a whole category of offenses where you actually cannot be detained by a judge who thinks the defendant is a danger. You can only be detained if you think they're a flight risk. So these category of offenses include second-degree murder, arson, kidnapping, and aggravated assault. The law's a little complicated because it kind of creates like double negatives in various places. I was just trying to read it. But it seems to me that you can be arrested for second-degree murder in Chicago. And if the judge thinks that you're not going to flee Chicago, but you're probably going to murder someone in the city of Chicago, you can't be detained. That's crazy. Honestly, I don't know why any of you live in Illinois, but it's okay. So that's bail reform. I want to move on to talk about kind of a few misconceptions about the criminal justice system that I find when I'm debating these issues. I talked first about bail reform because I think it's an achievable policy victory. I think those types of policy wins are necessary because messaging in the criminal law policy world has become very, very fraught and difficult because of the constant drumbeat of support that criminal justice reform movement has from media, academy, lawmakers, and more importantly, donor community. As someone who used to work in the Senate, there is a ton of money on the Republican side for criminal justice reform, and there's almost no money at all for anti-criminal justice reform. Local news does remain useful because of the constant drumbeat of crime news stories, but it's not what drives policymaking in DC or in state capitals. So in that vein, I want to talk about, like I said, 3 misconceptions about crime and incarceration in this country that I think are being advocated actually specifically by people who consider themselves right of center, people that are regularly invited to speak at Federal Society meetings. It's one thing to say that Republicans and Democrats, conservatives and liberals might disagree on stuff, but this is within the tent of the broader right of center conservative legal movement that these misconceptions are promulgated. So, number 1. We have too many people in jail for nonviolent crimes, and more specifically for nonviolent drug offenses. So, first of all, I actually want to push back on the notion that drug crimes are nonviolent. Now, regardless of your views on whether certain drugs should be legalized, the fact is that they are illegal in most circumstances. And because they're illegal, they exist in an illegal market. And participation in that market is generally driven by the threat of violence. Drugs are sold on contingency. Drugs are sold with the idea that payment will result in violence. In our society, whenever something is done of a threat of violence, as opposed to the threat of, say, a lawsuit or an angry worded letter, that is considered a violent act. That is the one role of government is to protect you from the possibility of violence being thrust upon you. So participation in the drug market, no matter how downstream or upstream, generally speaking, underlies a system that is built on the threat of violence, whether from a supplier to a distributor to a wholesaler to a retailer. Legalization is a different conversation entirely, but if you participate now in that market, that is the market that's being supported. But even assuming that some drug offenses of the many that are out there are in fact nonviolent, the actual stats are very different here. So less than 15% of drug offenders make up prison populations in state. 60% of state inmates are in jail because of murder, rape, assault, robbery, or burglary. Again, drug offenses are less than 15% of that. And about half of those drug offenders who are in state prison actually serve less than a year. That is not the population that is driving the United States' incarceration numbers. It's just not. So misconception number 2. We lock people up too quickly for long sentences instead of trying other methods of reform first. So this is a misconception that actually really grates on me because exactly the opposite is true. America gives violent offenders way too many chances before finally locking them up for a significant period of time. And again, the focus here needs to be on the state system as opposed to the federal system, because that is the predominant system that generates jail sentences and criminal actions, even though most highfalutin law schools focus on the federal system. So the reality is that only about 40% of people convicted of a state felony actually serve a prison sentence at all post-conviction. Sometimes there's time served that they've previously been detained. But only less than half of people convicted of a felony actually serve any prison time. And about 40% of the ones that do serve time serve less than a year in prison. And the median amount of time served is about 16 months. So even if, like, I'm pulling these stats from I think a Manhattan Institute study. So even 20% of convicted murderers and nearly 60% of those convicted for rape or sexual assault serve less than 5 years in state prison. Actual time served, as opposed to what their sentence might be. So again, I think there is a belief that we suddenly find someone who commits a crime for the first time and then suddenly send them away for 15 to 20 years. Anyone with any experience in the state system knows that that does not happen. You have many sentences, because people go to jail many times, but each individual sentence is actually very short, relatively. All right, third misconception. The purpose of incarceration is rehabilitation. This is a harder misconception to rebut with facts, because it's really about policy and principles and what you believe should be the purpose of society's role in incarceration. But I think it's one that's important to discuss, because society focuses a lot on talking about rehabilitation for offenders. And that is important. I am not anti-rehabilitation, especially when someone is in fact in prison. But rehabilitation, I forget if this is still taught in our 101 criminal law prof, but I learned it. Rehabilitation is only one of 4 traditional justifications for incarceration. And I think our national dialogue has forgotten the other 3, or at least they've minimized 2 of them, and they've completely forgotten the 3rd. So the 2 that do get some discussion is deterrence and retribution. And we could talk about that, but actually that does get some debate. It's just minimalized compared to rehabilitation. But I want to focus on the last one, and that's incapacitation. It's a difficult subject to talk about, but the reality is that historically, one of the purposes of locking someone up is to prevent that person from committing any more crimes against society for at least the time period that they are locked up. This is different from deterrence. Deterrence is about deterring other people from committing crimes. And it's not about retribution. It's not to make the victim of the prior crime whole. The idea is that as a society, when we're considering the pluses and minuses, the cost of incarceration, the downsides, we're thinking about, like, people always throw out stats, and we put someone in jail, it affects their family this way, it affects their future earnings this way. One of the things that we should also consider in that big picture analysis is what crimes might they commit if they were out of jail for those 3 years instead of in jail. And the reality is the types of people who commit truly heinous crimes are largely those with a significant criminal history. When they are on the street, they commit crimes that harm society. And one way to mitigate that harm is to not let them on the streets. And harsh sentences does factor into that. So take Chicago, for example. So of those arrested for homicides or shootings in Chicago in 2015 and 2016, 90% had at least one prior arrest. About 50% had a prior arrest for a violent crime specifically, and 40% had a prior gun crime arrest. On average, someone who is arrested for a shooting had nearly 12 prior arrests, and about 20% of them had at least 20 prior arrests before they are arrested for that shooting. And there was a study that looked at a 12-year period across America's 75 largest counties, which would include basically a significant percentage of this country's city population. And the results showed that 56% of the offenders had a prior conviction record. And even worse, it showed that 37% of the people that were convicted of a violent felony were currently on probation, parole, or bond at the time they committed that violent felony. So if you add those numbers to our terrible recidivism statistics, which is, I think, 83% of released prisoners are arrested for a new crime within 9 years. And going back to that drug crime thing, 77% of drug offenders are arrested for a non-drug offense within 9 years of being released from prison. But so given those numbers, both the idea that there are actually a small number of people that commit the large majority of crimes on the streets today, and our recidivism statistics, I do think it is legitimate for us to consider incapacitation as a basis for whether punishment should be stern lengths. And we need to be prepared to discuss that. So, it's something that I plan on doing. So I'm on Texas's Judicial Evaluation Committee, which advises 2 U.S. senators on who they should support for judicial nominations. Next month, we're interviewing candidates for district court seats. I want to ask them what their views are on the purpose of sentencing. I think too much in this country, everyone just defaults to rehab. And conservatives sometimes default to retribution because it sounds cool. But it really should be all 4 of those, because it is a complex system for why society should send someone to jail or not. So that's the big ticket item. And my tangent today is our last topic of the day. It's a bit of a tangent, I hope you'll bear with me. So I just talked about some of the major misconceptions about criminal justice in this country. Usually these misconceptions are weaponized by folks that are left of center policy advocates to advocate for what I think might be bad policy. But the reality is sometimes right of center commentators also buy into this, buy into a lot of these misconceptions, and are really, I would argue, are most responsible for the last 3 to 4 years of criminal justice reform movement in this country. It became a universal thing. So I imagine many of you might have followed the Ketanji Brown Jackson confirmation hearings last year. I assume at least the 2003 else in this room did, maybe not the one else who were in law school yet. But for those of you who were not following it, so during those hearings, a lot of the Republican members of the Senate Judiciary Committee criticized then Judge Jackson, for giving low sentences to individuals who were convicted of possession and distribution of child porn. And a lot of people actually got angry at the Republican senators, including within FedSoc, for going after Judge Jackson for that. They argue that it demonized smart sentencing reforms and the ability of judges to craft a more fulsome and personalized sentence. They also said that it was an unfair attack on Judge Jackson, who was no different than other nominees on this issue. First of all, I would say that I actually think Judge Jackson was actually a little bit further from the mainstream on this point, and the Republicans were right on that. But numbers, again, are pretty stark on this. So the average sentence in this country for child porn possession, which is possession, not creation of child porn, is 68 months. For Judge Jackson, it was 29 months, about 57% less than the average. The average sentence for child porn distribution was 135 months. Again, for Judge Jackson, it was 72 months, about 47% less. And again, this was not a one-off thing. It was an issue that she did care about, and she had her reasons for doing that. So, for example, in one case, US v. Hawkins, she dealt with an 18-year-old defendant who had downloaded child porn involving 8 to 12-year-old boys engaging in sex acts with adults. The sentencing guidelines range, which is the recommended sentence for those who don't know that, was 97 to 121 months for this defendant. Knowing who Judge Jackson was and her sentencing standards, the prosecutors in that case actually only asked for 24 months. They asked for 2 years. Instead, Judge Jackson sentenced the defendant to just 3 months in prison. During the sentencing hearing, she did say, "I feel so sorry for your family and for you, and for the anguish that this has caused all of you." She was talking to the defendant, by the way, not the victim's family when she said that. But even though I do think she was far outside the norm on this, those people that were criticizing Republican senators for going after her were right in one sense. While she is, I think, particularly bad on this topic, a lot of judges are weak on the issue of child porn sentencing. And while these are predominantly Democratic appointed judges, it also includes a lot of judges who get invited to speak at Federal Society events. A lot of judges that some of you might be clerking for. You'd be shocked at some of the names that are notoriously bad in sentencing child porn defendants. I probably shouldn't name names, especially if you guys are live streaming this. But there are judges out there that people in this room would respect who give sentences well below the guidelines range for these offenses. And the national numbers actually bear this out. Just to make sure I'm good on time. Yeah. So in 2019, only 30% of non-production child porn offenders received the sentence that was actually within the guidelines range. 59% received the sentence that was actually below the guidelines range. Almost 60% of child porn defendants get a below guidelines sentence. Sometimes it is the government that recommends this based on various reasons, but in over 70% of cases, the district court judge gave a below guideline sentence below what the government actually recommended. And the reasons that the judges do this, I want to give them full credit for this, or at least give them a fair shake, is they believe that current sentencing guidelines actually overstate the appropriate sentencing range for child porn offense. And this is where I'm going to kind of move it back to the broader point here. So basically, the idea is that sentencing enhancements, things that would increase your recommended sentence, that used to apply very rarely in the past, now are happening much more frequently. And this leads to an increase in your recommended sentence, and judges have taken it upon themselves to blunt that increase by giving below guideline sentences, so it looks like there's still a general, a bell curve of not as bad offenders and worse offenders, and kind of an average. And the reason why the sentencing guidelines range has gone up is that previously rare sentencing enhancements are becoming more common. But the judge's approach to this, I think, suffers from a few fundamental problems. just because something horrific and depraved has become more common in society today does not mean we should start punishing it less. That's basically the worst kind of moral relativism. And make no mistake, these sentencing enhancements are worth punishing people for. So, for example, there are a number of sentencing enhancements that are depressingly common today. So, to give an example, 84% of cases involve an enhancement for the sexual abuse of an infant, the sexual abuse of a toddler, or sadistic or masochistic conduct. 84%. I assure you, those numbers were much, much lower in the 70s and 80s. But I do think it is fair to say that we should not give a lesser sentence to people who collect images of the sexual abuse of an infant or toddler just because it has become more common. I'm using these stats because I've kind of been frustrated by how discussions on child porn and criminal justice issues go, because I had a debate recently at SMU Law School with a prominent libertarian lawyer who's a big proponent of criminal justice reform. And it is I've mentioned some of these stats, and his response was to talk about a case in Maryland where I think 16-year-old boy was prosecuted for child porn possession for basically sexting with his girlfriend. That's a crazy case. I don't know what the facts of that case were. I don't know why that prosecution happened. I don't even know anything about it. But it's a pretty common tactic in these debates to pull off one of those one-off absurd examples. But it's important to remember that cases like that are not representative. In reality, 99.4% of child porn cases involve prepubescent victims. 52% involve images or videos of infants or toddlers. These anecdotal responses to why certain crime occurs or doesn't occur, or why certain crimes might be absurd to prosecute, is particularly common when you see pardon authority being wielded, are not situations that should drive policy debates or debates in general. Someone once asked me, why do you think conservative judges supposedly are giving lower sentences to child porn offenders? The honest answer, I really think, is because these defendants don't always resemble what those judges usually see in their courts. They're usually white-collar professionals. They're usually people with no criminal history. They're usually people who are articulate in court. They appear with a family. They appear remorseful. And realities, like racially speaking, they're almost, not always, but there are a significant higher percentage of white child porn defendants than there are other races. So the best I can say for these judges is they get snookered by seeing defendants like this instead of your usual drug and gun defendants. But I shouldn't have to say this. These people are also bad. There's no reason why they should be getting lower sentences. So I think with that, it's 12%. I think I'll flop it over to you so we can give some time for some Q&A as well.
I actually brought slides.
Yeah.
Let me just say, it's very hard to do this ahead of time because I never know what you're actually going to say. So a lot of these slides are irrelevant. And I'm thinking about all the files on my hard drive right now and thinking about all the slides I wish I had made, not knowing what you're going to say. But I'll do my best. Okay, anyway, just want to say thank you very much for inviting me to do this. It's really a pleasure to get to come and give comments on a former student. When Jed Greenberg told me that my former student from as he said, my very first year of teaching, Prerak Shah was coming, I couldn't turn down that opportunity. I think we're going to agree on a lot of things, maybe more than we disagree on, which is a good thing for me because I'm robbed of the opportunity to turn to him and say with outrage, like, who taught you criminal law? Not a useful tactic in this case. Okay, I want to make, I guess I want to do four things quite quickly. One, I want to provide just a little bit of background about sort of the state of the world. The statistics that Mr. Shah provided you with are accurate statistics, but I want to sort of try to put them in a little bit more context. Then I want to talk about bail reform for a few minutes, about rehabilitation as a purpose of punishment for a few minutes, and then a sort of more general comment about what we should think about criminal justice reform looking like in modern America. Okay, so This is a chart of homicide rates and rates of change over time. So the line at the top is homicide rate, number of people per 100,000 in the population. The green and red bars at the bottom are increases and decreases percentage-wise per year. And this is what everyone's talking about. This almost 30%, 28.9% increase in homicides in the year 2000, the largest on record. Not the only big blip in history, of course. There's this big jump right here, right around 2003, that's over 20% as well, but a very large number. I guess I want to say a couple things about this. First of all, I don't have to tell anyone in this room, a lot of stuff happened in 2020, and so it's always important when you see statistics like this to think about whether what we're seeing is a general trend or a one-off sort of circumstance. The other thing is that the overall homicide rate, even after that big jump, is not that high for America in historical terms. It's about the same as the homicide rate in, as I said, 2003. It's about the same as the homicide rate in the late 1990s, which were generally viewed not as a time of sort of trouble in American society, but as a time of peace and prosperity. The late 90s were so good that Al Gore nearly got elected president. I'm not trying to make light of the homicide rate, I'm only trying to make light of Al Gore. So this is a meaningful jump. It's something we ought to care about and pay a lot of attention about. But it's not like all of a sudden, American society fell into decay and look at how much violence we had compared to history. This is just a deviation from the historically very low rates of homicide that had preceded it. Okay, so then what happened in subsequent years? So these are other crimes, by the way. Sorry, this is other crimes in 2020. As you see, robberies went down, rapes went down quite significantly. Violent crime as a whole was only up about 5%. Property crimes went down. Fast forward to 2021. Mr. Shah said this was the year where we hit our all-time high. Again, the murder rate increased another 4.3%, but the robbery rate went down again by about 9%. These are from FBI statistics. And then we don't have full data for 2022 yet, but it looks like there's going to be about a 5% decrease in the homicide rate for 2022. So I think we want to understand this sort of in the context of the broad sweep of American history, where what we see is a very disturbing rise in homicides, and of course any number of homicides is too many, but it might turn out to just be a statistical blip that fades pretty quickly as we get more distance from the pandemic. And so we ought to be quite careful about sort of making kind of broad-scale policy changes based on something that happens in 1 year when there are otherwise great disturbances to society. Okay, just want to also give some incarceration data. Mr. Shah talked about people who are in prison. Prison, of course, is just a subset of the total number of people incarcerated. We also have people who are incarcerated in jails. That includes people who are awaiting trial, people who are incarcerated for less than a year, which is usually jail rather than prison, people who are in immigration detention, etc. So as you see, these statistics show the incarceration rate per 100,000 people declining from a high in roughly 2008. It's down something like 20% overall. It's still an enormous amount of Americans behind bars. 2.1 million Americans. I don't have a good graph of the United States compared to other industrialized nations, but you've probably seen those statistics and seen that the US is vastly, vastly exceeding essentially all of our peers in the industrialized world in the number of people who are incarcerated. The other thing that's worth noting is that this broad decline in incarceration rates, which started in 2008, came at a time when the murder rate was low and continuing to decline. So this idea that I'm not sure that anyone was given the idea, but I want to, in case, disabuse you of the idea that we as a country started letting people out of prison and that the homicide rates increased immediately afterwards. That's not the story at all, based on these data. So we still have an enormous number of people behind bars. And I'm sure I don't have to impress upon anyone in this audience sort of what this means in terms of the human cost and the cost of the liberty of these people. The significance of the fact that they are deprived of liberty for extended periods of time and what that means and what we ought to be sure of before we take that step. Okay, so that takes me to bail reform. A couple of things. I agree with Mr. Shah that the Texas system in which you have to be offered cash bail unless you fit into one of a couple of categories seems like the wrong idea. It certainly seems like judges ought to have the power to keep people behind bars pending trial if they think that they're going to be very dangerous to the community. That is actually the law in Illinois now. Mr. Shah referenced the new law that had been passed in Illinois. It's called the SAFE-T Act. I don't know what the acronym stands for, but that's what they call it, the SAFE-T Act, that initiated bail reform in the state of Illinois. This past December, prior to the act taking effect, Illinois passed a series of SAFE-T amendments, which were geared precisely to addressing the issues that Mr. Shah brought up about the definitions of when judges could hold defendants in those cases. So here's just one of them I'm going to read to you. The amendments standardize language throughout to consistently apply the following standard for pretrial detention based on whether a defendant presents a safety threat. Quote, real and present threat to the safety of any person or the community, based on specific articulable facts of the case. So this concern that you have to identify a particular human being who's being threatened if the person is let out, addressed in these amendments. So I think of this as a nice victory for the legislative process. Illinois saw problems in the law, had concerns about what this would mean going forward, and the legislature took steps before the law ever took effect to correct them. There was some kind of backhanded comment about why anyone would want to live in Illinois. After that, I don't know, Illinois is starting to look a little bit better than Texas. I'm not sure, not sure what to say about it. Okay, the other thing I want to say about bail reform is that a lot of things get grouped under that heading. And I think that Mr. Shah is absolutely right that there should be bail reform of the form he's describing as necessary for Texas. Judges being allowed to keep people incarcerated if they present very clear dangers to the safety of anyone in the community. The type of bail reform that gets talked about a lot more is the elimination of cash bail and the fact that many, many people are released on their own, under their own sort of recognizance, as opposed to either having to pay money or, in many, many cases, being kept in jail because they don't have the money to pay. Those types of reforms have now started to be extensively studied by researchers. And what they do, I'm going to do this quite quickly, even though I have a whole slew of slides. What they do is they look at basically rearrest rates of those populations of people, people who would have been subject to cash bail before, but are no longer subject to cash bail now. And what paper after paper finds is that the elimination of cash bail does not increase rearrest. In other words, the people who are being let out under their own recognizance, as opposed to being forced to put up cash bail, or maybe not having cash bail to put up, are not committing any more crimes. No evidence that financial collateral has a deterrent effect on failure to appear or pre-trial crime. That's what we're talking about, people who are let out on bail before trial. Lots of different studies. Here, different paper. No detectable effect on pretrial arrest in this one, but a big effect on pretrial detention. And here's a third paper. Sorry, this is a little hard to read. For assault, theft, and drug crimes, there's no significant impact of bail reform on crime. For burglary and robbery, we similarly have no findings. So I think that the way to think about this is that there are large populations of people who, absent bail reform, are serving quite significant amounts of time behind bars before they've ever been convicted of the crime with which they are charged. And that, I think, should strike all of us as very concerning. To imprison someone, to take away their liberty before they've been convicted of the crime is a very significant thing for the state to be doing. And it's the kind of thing that we only want the state to do when there are extremely good reasons for it, when we have real reason to believe that that person would be dangerous if they were let out. And what these papers are showing is that a lot of these bail reforms, in which generally speaking lower level non-violent offenders are being released, are effective at giving people back their liberty, not depriving them of liberty absent trial, while at the same time not increasing crime. Okay, so that I'm going to come back to that point a little bit later. All right. Third thing about rehabilitation. So I think that the way I have always talked about this in my criminal law class is that rehabilitation used to be a thing. It was a thing in the 1970s. People talked about rehabilitation as a purpose of punishment. But it is basically not a thing any longer, that nobody really believes in it, or at least outside of academia, and they don't count. There's no political will for it any longer. And that now when we think about crime, we really do think about retribution, incapacitation, and deterrence. And I guess what I want to say is, I think that even if all we cared about was the safety of the law-abiding community, if the only thing we cared about was people who might become victims of crime, and I do not think that is the only thing we should care about, to be clear, but even if it were, we should still be in favor of rehabilitation to a much greater degree than we are now. There's voluminous evidence, these are all the slides I wish I had, voluminous evidence that the vast majority of rehabilitation programs pay for themselves manyfold. Because the problem, as Mr. Shah, I think, quite accurately put it, is that prison is criminogenic. If you go to prison, it makes you more likely to reoffend after the fact. People acquire sort of criminal habits in prison, they make social ties that lead them to commit more crime, and also prison deprives them of opportunities to engage in lawful work, to join the workforce, to have meaningful relationships, etc., by virtue of being in prison. So going to prison is devastating for someone's sort of life opportunities going forward, and that leads them to commit more crime, which is the thing we're trying to avoid. So there's a very strong case to be made that we should be investing a lot more money in sort of rehabilitative programs, by which I mostly mean kind of reintegrative programs, programs that make people better equipped to live nonviolent lives outside of prison after they're released from prison. Those sorts of social investments pay for themselves enormously. It's also it's an effective way of finding a program that's good for the people who are receiving it and good for all the people around them as well. I don't really know what the alternative to that was. I mean, Mr. Shah said that a lot of people he made the point that a lot of people who are arrested on their first offense serve relatively short terms of years in prison, and then subsequently after coming out of prison will reoffend, and the crimes often get more and more severe. I mean, I guess the alternative to a sort of move towards rehabilitation is to give people very, very long sentences upon first offenses on the theory that we know they're going to recidivate if we let them out of prison. But again, now we're talking about extremely serious deprivations of liberty that impose a dramatic cost on those people and the people all around them. And that's something that the state should only be doing when there are no other good alternatives left. And so, I think that in these cases, trying to prepare people for life outside of prison is a much better alternative. Okay, finally, I guess my final point is something like scalpel versus machete. I think that all of these sorts of points that both of us have made add up to kind of one thing, which is there are some people who are very dangerous and can't be allowed to sort of move freely in the community without posing a grave risk to the people around them. And there are a lot of people who are not like that. And they're all kind of locked up together in a lot of cases, so many of them for very long terms of years. And so there's still a lot of room. There are these thick margins for interventions that, if anything, tighten the rules in Texas against people who might be very dangerous, but then relax the rules for people who are much less dangerous. There are a lot of ways to do that. We can try to do that with law. There have been lots of programs to try to use artificial intelligence to get better estimates of who will be dangerous if they're released, let's say, pre-trial, and who will not be. I don't necessarily think that any of that stuff is going to be adopted wholesale in the immediate term, but what all those experiments show is that there's an enormous amount of room to continue decreasing the prison population, continue decreasing the amount of incarceration that people, before they've ever stood trial, are subjected to, while still not increasing the amount of crime in society, not increasing the amount of danger to the community. And so I think that those sorts of targeted measures are what we ought to be talking about. And I agree with Mr. Shah that I think these are things on which people all across the political spectrum ought to be able to find common ground. Okay, I'm done. Thank you all.
We can open up the Q&A. So two quick little things there. I think, so on the amendments to the Safety Act, that sounds good, but it looks like when I was one sitting there. It looks like that only affects situations where judges can already detain someone for danger to the community. The idea that there are certain offenses where you can't do that at all is still in law. So like arson, second-degree murder, stuff like that. In those things, you can't detain them if you think they're dangerous, only if you think they're a flight risk. But it is better. The amendments do make things better, though. I do agree. And on the rehabilitation point, on the idea of funding it more, I think a lot of people would stand up and say, yeah, let's fund more money there. I actually don't think we should. And the reason why is not because I don't think they're valuable programs. It's that, for the most part, there is a finite amount of money that people will spend on issues that don't affect them directly. Like, generally speaking, budgeting, especially in state systems compared to federal system where they have, for the most part, balanced budgets or they go defaulted. Generally speaking, you're not going to spend money on a lot of stuff. And as great as it would be to throw more money into rehabilitation, if we can take that pot of money and put it in other places to prevent the first criminal act from occurring, even though those are harder sometimes, that is probably going to be more successful, because even with rehabilitation programs, even if they don't pay for themselves, recidivism rates still are high. Even if we were to increase that, maybe they go down a little bit, But the idea that when someone goes to jail, they're likely to reoffend is true. And it's why we should try to prevent them from going to jail if they don't have to. So I wonder if spending that money in community programs or like education, anything like that, would be a more useful use of, again, finite resources. So anyway, I want Q&A, so.
Thank you, Professor Mason. So yeah, so we'll now go on Q&A. We've got about 10 or so minutes for it, so plenty of time. If anyone has any questions, please raise your hand. We'll call on you.
Yeah, thank you so much for coming and doing this talk. It was very, very interesting seeing kind of both perspectives. My question is about your attention on, just kind of on that last comment, your attention on kind of preventing the first crime and not trying to take policies to reduce that recidivism, which rehabilitation and rehabilitation programs seek to do. You painted this picture of people crying, or people going to prison and it generating reoffense and reoffense and reoffense. It seems to me the solution would be to try to structure policies and structure both our prison system, the way it's structured where we send people, not mixing them all in one general place depending on the offense, but also how we introduce them back into society and how we treat them to lower that recidivism rate. That seems like a more effective use of resources. So why is there such an emphasis on punishment and in the first instance as opposed to trying to combat the problem of recidivism?
Sure. I think that's actually two questions. Yes. Sorry, yeah. On the rehabilitation side first and kind of the punishment emphasis side. On the rehabilitation side, look, if there was a way to say we will spend this amount of money and we will be able to reduce recidivism this way, or be able to do it in a measurable way of a significant change in recidivism statistics. As far as I know, and again, not an academic, I haven't done like a fulsome study of this, that doesn't exist. So it becomes harder to pitch it. It becomes harder to say that this specific program will cause this specific result. So while in theory, I agree with you, it'd be great to spend money on things that cause less crime from occurring. The idea is if you have $1 million, you just have one bucket, we're not gonna be able to increase that. If you find a way to get more money into the prison system for stuff, that's awesome. That's a fight I've stopped waging because you're just never gonna get it. But if you have a finite amount of money that you're gonna be able to spend on these types of things, where can it do the most good? There are a lot of things that can prevent the first crime from occurring. That's generally speaking education, social services, mental health care, things where you can actually see a measurable impact on if these people had certain resources, they will probably not commit a significant violent crime. So if you were to, I would just say that I would probably rather spend money there than on someone that has already committed a crime, with the idea that, again, these recidivism statistics are so bad that it would require a significant amount of a decrease there for it to actually compare to not committing crime in the first place. But I'm not pretending that that's the right answer because it's such a hard thing to measure what's going to go in that. Because I don't know. I imagine you disagree. So
Can I say something?
Yeah, sure, yeah.
I mean, look, you're absolutely right that there are well understood programs out there that will prevent people from ever committing the first crime and also more than pay for themselves. James Heckman won the Nobel Prize for showing that universal pre-K education more than pays for itself because people with better kids grow up in better circumstances. with better education, they don't commit as much crime. It's better overall for society. I mean, if you look around the country, though, not a lot of universal publicly funded pre-K programs. We are, as a society, we don't have the political will to spend money on these things, even when we know that they're going to work well. There are recidivism programs that have similarly been documented to more than pay for themselves, to reduce crime to a degree that the social gains are greater than the social costs. But I mean, again, I think like since we're talking about the way that we talk about crime in the public sphere, like I think that the framing that you used is very common but unfortunate, the framing of why would I want to spend money on someone who's already committed a crime. When you say it that way, everyone's answer is, of course I don't want to spend money. But if we reframed it as, you're spending money on yourselves, you're spending money on building a safer community for yourselves. And yes, it happens to help this other person as well, but it's really about you. Maybe the amount of public support would be a lot higher.
And your second part was on the punishment versus retribution question. I will say that, so like one of the statistics that Professor Mazur mentioned was that basically our incarceration rates versus other countries' incarceration rates. I think there was a study recently that actually looked at it. It's interesting. It's not that we send people to prison more often than other countries, like again, per capita. It's that when we do send them to prison, we generally have slightly longer sentences, especially for violent crime. So again, it is actually more tied to not like higher crime rates, but it is like our American impulse towards retribution. And what I would say is, that's a value I have. It might be a value that other people don't have. Like that does come down to what you want society to be. Some people think that retribution, the idea of society making a statement on the wrongness of an act and punishing it accordingly, taking away someone's liberty because you did this to our social contract, that's a valid view to hold. It's within the realm of like what you can do as a society that you've put together with legislative changes and stuff. Some people might disagree with it, but to those who don't, I would encourage you not to back away from making the argument that, yeah, you know what, I'm a retributivist. I think that we should punish crimes. I think that is a valid expression of society's disapproval and we should do it. That doesn't answer your question, but it's more to the point that like you're assuming it's a negative value towards retribution, but that's not true for a lot of people, and I would just encourage people to stand for that if they want to. So, yeah, Art.
Yeah, thanks for coming. I guess my question is, what's the limiting principle for like this argument that we should incarcerate more people for longer? Like, insofar as you recognize
death penalty for everything, right?
Right.
Yeah.
So like, insofar as you recognize that like already America incarcerates people for significantly longer than any other industrialized country, but we also have higher violent crime than any of these other countries. Like, feels like we've tried the incarceration thing, and even if it's declined a little bit, we still have this very significant problem. We just keep on pushing that button and double incarceration rates.
The quick answer is yes, but I don't actually need to be that flippant about it. But I think the way you see it is, what we do is we tend to go from nothing, 30 years. Nothing, 30 years. As a whole, like if you look at like median sentences, it's not a bell curve. It is, like the numbers I was saying earlier about the average time that someone serves, the average time that the sentences people get remain pretty low. And then suddenly we realize after they've done 30 terrible acts, after they've done all this, after they've probably murdered someone, that, all right, now we're gonna lock them up and throw away the key. What I think we need is a little bit more gradation in those punishment ranges too. And again, you're asking what the limiting principle is. It's always hard. You always want to say, like, that's what value judgments are for, but sentencing enhancements, stuff like that. Like, we think this is worse, we think this is less worse. So there is a way to kind of gradiate that punishment, but it's more just increasing that level. And two, it's when society's decided that a certain crime should have a certain sentencing range or something like that. The problem we're getting is that people aren't serving that amount of time. Maybe if they do that, we would have gone a little bit too much to the extreme, but what we're seeing now is them serving less than 5 years, less than 2 years, less than 1 year. So it's more getting back to a gradation of punishment where they actually serve more time for slightly more offenses.
Yeah, we have time for one more. Matt?
What's the impact of drug legalization on your theory here? Because it seems like one of the big problems is, as you've said, creating a black market for drugs makes these sorts of crimes more dangerous. You know, I think you said like 15% of people in prison are on drug offenses, and the recidivism rate for people in prison is really high. So it seems like if we legalize drugs, or at least scale back criminalization, it would solve at least some of these problems, right?
Maybe. So that 15% number does not necessarily include, I mean, it doesn't include just all, like just marijuana offenses. It is all drug crimes. So like heavy levels of trafficking all the way down to, I mean, the reality is very few people actually serve jail time for possession these days. It's just not a thing in terms of resource allocation. The honest answer is that's a whole nother speech, and it's one that, like, I mean, like, we were starting to see examples of situations where drugs are somewhat legalized and it's not going well. Like Colorado and a few other places where there still remains violence underlying a lot of those markets. Some people would say that's because it's still legal in the federal system, there's less banking. Some people would say no, it's inherent to the fact that you're going to have other countries with illegal product that can undercut legal markets, which have a lot of like, there's so many different factors. To the extent we have information from these states, I think the studies show that like the increase in tax revenue has not offset the decrease in, say, property values and other like property crimes and stuff like that from certain areas. What I would say is that for the most part, very few people affect violent crime rates, incarceration rates on a purely using drug basis. It's just not a factor in these larger scale discussions. It's either someone that's engaging in a violent enterprise related to those drugs, or it's someone for whom, or like the vast majority of crimes like I talked about aren't involving drug offenses at all. So if we're gonna solve something, that's not where I would go to first.
Okay, well that concludes our event. Thank you so much.